The Department of Justice is done with the corrupt Trump judge Eileen Cannon, and they filed a motion to expedite their appeal. Meanwhile, Trump tries to get a new judge in the New York Attorney General lawsuit, and Tish James, meanwhile, says she's ready to go to trial soon. She wants trial to be set in 2023. Let's go. The jury selection in the Oath Keepers' seditious conspiracy trial before District Court Judge Amit Mehta with criminal defendant Stuart Rhodes and his co-conspirators. That jury selection process wrapped up last week. The panel will be sworn in on Monday and trial starts this week. Meanwhile, a January 6th insurrectionist named Kyle Young is sentenced to 7 years for his involvement in the insurrection, and the federal judge presiding over that matter, Amy Berman Jackson, standing in stark contrast to everything Judge Eileen Cannon is doing, and here slamming the un-American MAGA movement in no uncertain terms. And in the E. Jean Carroll defamation case, which was removed to federal court and subsequently appealed by Trump to the Second Circuit, the Second Circuit Court of Appeals ruled that Donald Trump was acting as an employee at the time he made the potentially defamatory statements. The other questions at issue were certified to go to the D.C. Court of Appeals, but this may lead to the dismissal of that action, not for certain. But New York just passed the Adult Survivors Act, reviving the statute of limitation for sexual assault. So regardless, Trump is going to be sued by E. Jean Carroll for sexual assault when the law officially comes into effect. The most consequential legal news. I'm Ben Meiselas, joined by Michael Popak. This is Legal AF. Michael Popak, how are you doing this weekend?
I'm doing great. I'm doing really great. You know, it's funny when you did the intro for the section on the 11th Circuit we're going to talk about first, I had the exact same note. This is when you and I have that Vulcan mind meld about with underlining the Department of Justice has had it with Eileen Cannon.
You know, the Department of Justice, they previously filed that motion for partial stay, which was granted by the 11th Circuit after being denied by Judge Eileen Cannon. So they got the 100 classified records back, which they said, this is what's going to cause us that irreparable injury and irreparable harm. So they got that back. And I think they were thinking to themselves, you know what? We can tolerate Judge Eileen Cannon in this process. At this point, the special master that was appointed, Judge Raymond Dearie, is a respected judge who follows the law. Judge Raymond Dearie is going to be the one making recommendations to Judge Eileen Cannon. Judge Eileen Cannon, she's not, after being, essentially reversed by the 11th Circuit in such humiliating fashion, like she's not going to keep making these horrible orders. And so let's just let the overall appeal process play out, because let's not forget the motion for partial stay was not the appeal. That's a motion for partial stay pending the appeal, because as we know, and as you know, as loyal Legal AF listeners, appeals take time, right? There's a briefing schedule that's fairly long with an opening brief, a reply brief, a response brief. The irreparable harm was those classified records, and the Department of Justice was like, look, we'll tolerate a normal, slow process until Judge Eileen Cannon continued to make these orders that totally fly in the face of the law, that fly in the face of comity with COMITY, comity with the special master making the recommendations. And this past week, she rejected the special master's recommendations that Donald Trump, as the plaintiff bringing the case, should file an affidavit under penalty of perjury in response to the Department of Justice's affidavit of the evidence log, either confirming or denying that that was the stuff that he took and was being kept in Mar-a-Lago. That's what Judge Dearie said, because, hey, you're the plaintiff. submit an affidavit as the plaintiff in a civil case. And I, as the special master, I want to make sure that I am dealing with an accurate set of documents. So later, nobody's going to make arguments. Oh, the process was confusing to me and these were not the real documents. She, sua sponte, swoops in and she goes, he does not have to file a declaration under penalty of perjury. How dare you, Judge Raymond Dearie, force the plaintiff to submit an affidavit under penalty of perjury? That's not what I envisioned in this process. One of the other things Judge Raymond Dearie also requested is that on a rolling basis, rather than wait to the end, with the thousands of documents that are still in play, that Trump responds to his various bogus privilege claims on a rolling basis versus waiting to the end. Judge Eileen Cannon swoops in, goes, why would we do it on a rolling basis? Let's just wait. In fact, let me push back the dates to December 16th. And then finally, Judge Raymond Dearie said, you know what? The Rule 41G motion, which is a federal criminal rule of procedure about return of property, I'd like the parties to brief if that should even go before me or Judge Cannon. Shouldn't that go before the magistrate judge, Judge Reinhardt? I want you to brief those issues. And then Judge Eileen Cannon swooped in and said, how dare you? How dare you request that the magistrate potentially hear this? Like, let's not even brief the issue. I asserted extraordinary equitable jurisdiction. That was in the footnote of her ruling. I asserted the equitable jurisdiction. This is mine to make the ruling on. And so when that happened, I did one of the quick video hits that I've been doing on the Midas Touch YouTube channel. And I said, they're going to file an appeal so quickly on this because these orders are just insane and she's got no credibility. And boom, the Department of Justice filed for a motion for expedited appeal saying, let's get the show on the road. We want the entire briefing done, no extensions by November. And let's make a ruling right now, 11th Circuit, that Judge Eileen Cannon shouldn't even have jurisdiction over this at all. Like, she should never have even exerted equitable jurisdiction. She has no jurisdiction. Stop this whole process right now. Popok, you want to go into what that motion said?
Yeah, I'll give comment on some of the other things that you said. I think the Department of Justice, as we had predicted, was willing at one point, and that point has long since passed, to live with Judge Cannon and work around her and thread the needle to try to find a place of expediency to do what we keep ignoring every time we talk about these things, not you and me, but others, which is there is an ongoing pending criminal investigation that has been completely hamstrung, and blocked by a federal judge on behalf of a former president of the United States. That's extraordinary that any potential criminal defendant would get that. Or as Tristan Snell, one of our fellow talking heads on legal, tweeted, Trump finally found the criminal defense lawyers he was looking for in the form of Eileen Cannon. It's a great line. So that the DOJ has been, as it always has been under Merrick Garland, very sober and realpolitik in their approach to things. Like, we don't like Eileen Cannon. We think she's made a bad ruling as of September 5th, her original ruling, but let's find a way to maybe live with it without inviting the ire of this young judge. So we'll appeal, as you outlined earlier, Ben, we'll appeal part of what she did. Let's get those 100 classified documents and empty folders back so we aren't inhibited. And then we'll deal with the other, and that'll be the immediate stay that we brought a motion up to the 11th Circuit. Let's get a new set of judges because we're not doing well with Judge Cannon. And they got a great ruling out of the 11th Circuit that you and I covered extensively. A 3-judge panel. It'll be the same 3-judge panel for this briefing. And they got great rulings. Even an invitation, I believe, and I think you and I talked about this, from the 11th Circuit to bring back a bigger case. They said, we are only here on the very narrow thing the Department of Justice has asked us to look at, which is the 100 documents. But when they wrote their order, originally, the 11th Circuit gave a very broad and sweeping analysis as to why the Department of Justice was right and Judge Cannon was wrong at every turn. The Department of Justice had to be heartened by that and had that always in their back pocket, that if they ever go back to the to the 11th Circuit, they have a friendly, receptive panel who is already on their side on the major issues, which are national security is at stake, a criminal investigation is at stake, and Judge Cannon went way too far beyond her powers, beyond her jurisdiction in ordering these things. And the Department of Justice had to say in their back pocket, if we ever have to go back there quickly, we know we have a receptive audience because we see how they've analyzed it and how they've slapped and reprimanded Judge Cannon. So they sat and patiently waited. It's a patient organization, the Department of Justice under Merrick Garland, to see what Cannon would do next. They were heartened in the beginning. Look how quickly things change, Ben. How sands shift so quickly. They were heartened by Judge Deary, the judge that you and I were thinking about. Well, maybe they picked him because of Carter Page and prior problems. Judge Deary is the only judge with any gravitas that's involved in this case other than the 11th Circuit. And he started issuing really great rulings for the Department of Justice and for democracy. You think I've heard all this crap out there about the FBI planting Trump. Okay, file an affidavit and tell me if you have any objection to any part of the inventory and tell me what's been planted or what's not been planted, or we're not going to ever hear about that in this courtroom again. And other things that were consistent with the delegation of authority that he was given by Judge Cannon. So what does Judge Cannon do? As you said, she clips the wings of a more senior, experienced judge in Judge Deary, who's still a senior judge, federal court, Eastern District, New York. He's not retired. He's still a brethren of hers. Clips his wings, says, nope, you got it all wrong, and all the reasons that, Ben, you outlined. Which leaves, by the way, we haven't talked about it yet, but it leaves Judge Deary in a really weird place, because if he can't do the job that he thinks he's been given because he's getting micromanaged by Judge Cannon, he may walk. At a certain point, Judge Deary may say, you know what? I don't need this. I have a job to do. I'm not being allowed to do that job in the delegation by Judge Cannon, and I'm out, which would be a major delay, of course, if the special master stays in place. So having watched her recent rulings on Thursday, the Department of Justice must have slapped their collective forehead. I'll do it here for people that watch us. And said, we can't live with Cannon anymore. We thought once she turned it over to Deary, she'd let him do his job. She's not letting him do his job. She's interfering again. We have a receptive 11th Circuit. Let's file our motion now for an expedited appeal on the remaining 11,000 documents, because they shouldn't be sitting with the special master either. And what they said in that application, Ben, to the 11th Circuit, to that same 3-judge panel is, let's get all this done all briefings should be done by the 9th of November on both sides. So it's fully briefed, full-blown appeal for the panel to consider on the remaining 11,000. The special master should not have been appointed by Judge Cannon. That's the appeal. The 11,000 documents shouldn't be sitting in Brooklyn. They should be back with the Department of Justice, who has a job to do, a job the 11th Circuit already recognized, which is to defend democracy, to protect national security, and to investigate a potential crime. Let's not forget, the Department of Justice and the FBI is charged with investigating crimes. They've said it's not just the 100 documents, 11th Circuit panel. It's the 11,000, some of which were commingled with the documents that we now have back in our possession. And we can't naturally investigate and follow leads wherever they take us as to the commission of possible crimes. And not just classified documents is the crime, they reminded the 11th Circuit. The criminal statutes that are cited in the original search warrant, as you and I talked about at length, talk about statutes that have nothing to do with classification, including statutes that predate the classification system, like the Espionage Act, having nothing to do with it. So you need to lift 11th Circuit all inhibitions and prohibitions on the FBI and the Department of Justice to do our job and do it now and get everything briefed by the 11th of November. I think they have a receptive audience in the 11th Circuit. I think they're going to get expedited briefing. And I think ultimately they're going to win, and Cannon's going to be out of this case, as is Judge Deary, either by his own hand or because the special master goes poof when the appellate court rules in the favor of the Department of Justice. What do you think, Ben?
Oh, I absolutely agree with you. And what the Department of Justice pointed out to the 11th Circuit is, your same analysis why she doesn't have equitable jurisdiction when you apply those factors of that case, that is the controlling case about any judge who wants to extraordinarily assert equitable jurisdiction has to maintain that these factors are present. And you've already ruled that there was no callous disregard by the Department of Justice. In 11th Circuit, you said that the inquiry by Judge Eileen Cannon should have ended there and she should not have asserted jurisdiction. But then you continued to go down all of the other elements as well under the Ritchie test and found that even under those other elements, under any element, she should never have asserted equitable jurisdiction. Like, how could you claim that Trump would have irreparable harm to documents that he can't possibly possess? And if you're claiming that Donald Trump would face irreparable harm, you're essentially saying anyone who robs a bank will just say, hey, I'm going to be harmed if you criminally investigate me. That's going to harm my reputation. And that's the dumbest possible legal analysis, is essentially what the 11th Circuit said. So the Department of Justice said, you've already analyzed these issues. The same exact analysis applies here. Let's not delay this anymore. One other point I want to make before going to the next topic, which is how unprecedented it is for a federal judge just to overturn a special master's recommendations when they appoint the special master to do the specific task and they then carry out the task. Even if it wasn't a distinguished senior status former chief judge of the Eastern District like Judge Dearie, if it was a private lawyer and a federal judge did that, it would raise lots of eyebrows and go, huh? Then why would you appoint the special master in the first place to give you those recommendations? Like, you almost never see that type of thing happening. Now, the fact that she's doing that to a judge who's like one of the most respected judge, who's been a judge for like 4 or 5 decades, who has presided over some of the most consequential cases in New York, from mafia cases to FISA-related cases. And this new judge is going to say, I'm overturning your recommendation that the plaintiff in a case should not have to submit affidavits in support of their own case, is the most batshit crazy stuff. And look, you and I could go on and talk about this.
One thing. Yeah, on the batshit crazy, because there's a lot of Twitter feeds about how do you get rid of Judge Cannon, and hats off, to the Department of Justice, who I think has had the win in the bank since their prior ruling and did not immediately go for the full appeal on the 11,000 documents, but waited to see what Judge Cannon was going to do next. They got this win in the bank. It's as you said, it's the exact same analysis that it doesn't give her jurisdiction over the 11,000, over the 100, doesn't give her jurisdiction over the 11,000.
Exactly.
So I think it's a win. Now, why did they wait? Because they're trying to do this fast. They got a criminal investigation. As to the removal of Judge Cannon, originally I was always like, listen, I've had judges, so have you, who you haven't liked their decisions. But it doesn't mean, as terrible as those decisions may be in your mind, it doesn't mean it's, fraud or corruption or disqualification grounds or recusal grounds to get rid of the judge. However, having now watched her a few times, there is a petition that the Department of Justice could bring. And I think it could go to the chief judge of the Southern District of Florida, who sits in Miami, or to the 11th Circuit. It is not unprecedented for an appellate court to remove a trial judge because they find either incompetence, bias, the appearance of impropriety or bias, which is what the rules on judge recusals and disqualification says. If they think she has now gone so far that her own rulings will be challenged for appearance of impropriety, the 11th Circuit itself, if the Department of Justice were to ask, could remove her. And I think the Chief Justice could too. But here you go. The Department of Justice, there's an old line about assassinating a king. If you're going to shoot the king, you better kill the king, because if you shoot and miss, you just have a wounded, pissed off king. If you go for the federal judge and you lose, you're stuck with Cannon, who now knows you tried to remove her. So I'm not sure this Department of Justice does that, but there is a method to remove the trial judge through the 11th Circuit, should they so choose.
Shifting gears to New York now with the Letitia James, the New York Attorney General's $250 million fraud lawsuit against Donald Trump, his adult children who purportedly run the business, Weisselberg and others. This lawsuit would also enjoin or stop Trumps from being on the boards as managing members or directors, basically stopping them from doing business or running businesses. It would be about a 5-year ban from buying property in New York, but basically it would be the civil death penalty for the Trump organization if this case prevails. When this case was filed, it wasn't assigned yet to any specific judge. But one of the things the New York Attorney General, Tish James, did was they filed a notice of related cases to Justice Arthur Engoron. And Justice Arthur Engoron was the justice who presided over the special proceeding where the New York AG, Tish James, was issuing the subpoenas and gathering the discovery that was the precursor to the lawsuit that was being filed. And that in that special proceeding, right, Donald Trump was held in contempt for not turning over the discovery. He was basically fined and sanctioned by Justice Engoron over $100,000 that he had to pay. Alina Habba was Trump's lawyer on that case, and apparently she still is representing Donald Trump in this case. So a notice of related case just basically says one matter is related to the other matter, and so therefore the judge who presides over the other matter should hear both or multiple matters because they're familiar with the facts of the case. And for judicial efficiency and judicial economy, why would you have a new judge have to relearn everything? One of the things that Trump's lawyers did, though, in response to the Tish James lawsuit, though, is say this should not go in front of Justice Arthur Engoron. They said it should go in front of the complex commercial division within the New York court system because it satisfies the elements of being a complex commercial dispute. And they filed a letter brief to the administrators of the New York court system earlier this week. And they said Tish James should not be able to transfer this case or get this case related to that same judge. They don't like Justice Arthur Engoron because he followed the law and held Trump accountable. And they want to try to go judge shopping for a judge who more resembles an Eileen Cannon, although you'll probably have a little bit more difficulty finding that in New York. But nonetheless, that's what they're out basically fishing for. And then in response to that, well, I would say shortly after Alina Habba asked for that this goes to another judge, the New York court system immediately assigned it. They allowed the related case to go forward and they assigned it to Arthur Engoron. And then on September 29th, Tish James in the New York AG's office filed a letter and said, look, Alina Habba isn't wrong in the sense that this does satisfy the complex commercial division requirements, but it's long been held in New York that that's not dispositive. Cases could and should go before the related judge in circumstances where that meets the judicial economy. And here, all of those factors would make sense. And so it's not an absolute that if you satisfy these requirements, it goes to the commercial division. It should stay in front of Justice Engoron. And not only that, we're ready to go to trial in 2023, and we're going to ask Engoron for a 2023 trial date. And so there's no reason at all to even address or deal with Alina Habba's motion. It's before the right judge. This is more delay. And one of the things that Tish James says is, we know Trump's tactics by now. His whole thing is delay, delay, delay while he is engaged in active criminal fraudulent conduct. And so this case needs to be heard now. None of this Trump BS. We're ready to go. And Judge Engoron or Justice Engoron knows the case. And Popak, you know a lot about this procedure. This is your, one of your home courts, this and Florida. What do you make of these moves?
Yeah, well, let me first say that what we're doing right now on Legal AF, I think this is why people tune in for us, is completely different than mainstream media reported this. All the headlines from mainstream media were Letitia James, New York AG, moves for immediate trial as early as at the end of 2023. That's not the headline. The headline should have been what you outlined, which is Trump tries to forum shop, get a better judge than the judge that was assigned to the case, and tries to do it by way of asking for a transfer to the commercial division or an assignment to the commercial division. That's really the heart of the story. And then I have one observation about the NYAG's comment about there's an ongoing fraud. We got to hurry up and try this case. I want to talk to you about that in a minute. But you have the procedure exactly right. This is my backyard. This is where I practice. And let me just say, because it's true, and I practice there. The judges of the commercial division are very good. There's 4 of them, 5 of them. They're very good. I appear in front of them regularly. I've transferred cases to the commercial division that were complex in nature and that belong there. But that's not appropriate here, and that's why the New York administrative judge did not heed the request by the defendant here to transfer the case to the commercial division. If there wasn't a prior case, which you call properly the special proceeding, that Judge Engoron already presided over, with 800 court filings, with tens of thousands of documents already reviewed by Judge Engoron in his supervision of the investigation by Letitia James's office that led to the filing of the civil lawsuit, right? That's why they're related. He already has the learning curve. It would take a year, or even if a judge in the commercial division dropped all of their other cases, and they have thousands of cases in front of them, they have, this is New York. This is like, we call it almost like deli justice. Number 38. Okay, what do you want? Half a pound of pastrami, and you wanted me to decide your contract case? All right, great. You don't have a lot of time with these judges. In fact, a little known fact for people outside of where I practice, and I think this happens in California where you practice a lot too, Ben, is that the law clerk, the law secretary, it's called, for each judge is almost like a mini judge. It's almost like a magistrate. And they make a lot of preliminary rulings on things other than discovery substantively as if they were the judge. They're not elected. They're lawyers. Some of them want to be judges in the future, but they are the law secretary. They hold tremendous power over a case. And each one of the commercial justices, for instance, has a law secretary, as does Engoron. So that's the process. Normally, a case like this, because it is complicated, would go to the commercial division. However, Judge Engoron, who's better than Judge Engoron, who has all of this body of work that he's done already. So there's only one judge that's ready to take this case to trial in 2023, which is what the AG's office has pointed out, and that's Judge Engoron. The only part of the of the letter, which was successful, they successfully got it back to Engoron when the case assignment came out. And he'll now be trying the case, and now he'll decide at a hearing. They've asked for a expedited preliminary conference in front of Judge Engoron, which we'll report on when it happens. And they've already telegraphed that they're going to ask for a 2023 trial date. And I think he's going to give it to them. The only aspect of it that I thought they went a little bit too far is when they said, this is an ongoing fraud and we've got to hurry up and try this case. Well, listen, if it's an ongoing fraud that you're really worried about, then what's the thing that you move for?
Say that one more time.
If it's an ongoing fraud that you're worried about, what do you move for?
You move
in the
for
courtroom?
A temporary restraining order,
which they haven't done here. So maybe they will, and then they can really pound their chest in the courtroom and say, oh my God, it's an ongoing fraud, and we need to stop it immediately to stop banks and other victims from being victimized. And maybe they should, but they didn't.
Popak, that was a bit of a law school moment for me right there by you. I'm
sorry, Professor Popak. I was like Kingsfield in Paper Chase.
I had a little bit of flashbacks to law school there. So for those who are listening on the audio, and we'll keep that in the pod. So I'm at my mom's right now, and I just flew back from Europe, and so I was just getting a text message about what did I want to eat for lunch, and so I was not paying attention to anything Popak was saying.
Oh, that's terrible.
And then Popak's like, what do you call that, Ben?
I called you out.
It was just like in law school where you'd be G-chatting or whatever with the people in your classroom. And what do we call that, Ben? Can you repeat the question, Professor?
By the way, that was really fun. I did feel a little bit like Paper Chase. Mr. Marcellus, what do you call the thing that you file in a courtroom? Yeah, it's an injunction, and they didn't file the injunction. Listen to me, Ben. You have to listen to me more on this show. So that's that. That's where we are. It's going to stay with Engoron. Alina Habba can stamp her feet all she wants. It's not going anywhere. The judge they hate, the judge that already found, as you said, Trump in contempt, the judge who has looked at tens of thousands of documents, doing his in-camera review, who's already formed an opinion about whether, and has denied Alina Habba's motion to dismiss the investigation for being politically corrupt and biased because Letitia James has it out for, and she's a racist, and she's at all the Trump bullshit defense stuff. This is the judge that's basically said, that's not happening in my courtroom. So they don't want, I don't think, though, you said this as we led into the segment, he would not get a better audience for his shenanigans, to put it mildly, before the commercial division judges. I know them. They are no nonsense. They deal with some of the most complicated commercial matters in the state of New York, which means in the world. From real estate to securities fraud to, this is a very sophisticated set of judges at a very sophisticated courthouse, but he would get delay because they would never be able to come up with the learning curve, the body of work that Engoron already has. So he'd get that, but he would not get a more favorable audience. And, he would like to start all over again with somebody, even though, they would know what happened in the prior proceeding. They wouldn't know it the way Engoron did. So there we are. Sorry, you can go back to your texting.
And that difference right there is dramatic, though, because, I've seen firsthand from, in LA, we've got a 5-year rule. A case needs to go to trial within 5 years, or else the case can get dismissed unless you go to the judge. Like in New York, like the 5-year rule, and I'm not trying to mock your New York courts, Popak, but like the 5-year rule sometimes is like within 5 years you get your first status conference sometimes. Right. And like in New York, those cases, especially in the Supreme Court, which is actually the trial court, they have weird names in New York. The Court of Appeals is the Supreme Court, the Supreme Court's the trial court. But those cases, like cases in 2012 that I'm aware of, are going to trial now because everything gets appealed and then it goes back. So the fact that it will stay in front of Engoron is a major difference maker.
I'll give you to prove your point. I left in-house counsel position over 3 years ago. I just got a notice on a case that was going on when I was there. And now after 4 appeals during the process of the trial, they're just now at a complaint, at a final complaint after 3 years of pleading that they can now use to move forward. So it was 3 years just trying to figure out if the party had a proper complaint or not, or causes of action.
Yeah, and that's what Trump wants. Delay. One of the things, Popak, about covering all of these Trump criminality cases on Legal AF is you start to really learn about these judges, and like the judges become these characters in this Trump crime drama, right? We've heard the name Amit Mehta, because here's the thing about federal judges, unlike a lot of state court judges, at least in California, like in California, you've got criminal state court judges, you've got probate state court judges, you've got civil state court judges. A judge doesn't hear criminal and civil matters in state court proceedings here in California. But in the federal court systems, a judge who will hear the criminal case also hears the civil cases. So someone like Amit Mehta is presiding over a lot of these civil lawsuits that were filed against the insurrectionists and ruling on the torts and the tortious conduct at issue that causes monetary damages. And so we've talked about a lot of his detailed rulings there, permitting those civil lawsuits primarily to stay intact. He's dismissed one or two peripheral characters, but the main cases have been able to proceed and go through on the civil cases. But he also has presided over a number of these January 6th insurrection cases and insurrection trials. I mean, heck, he's also the judge overseeing the Peter Navarro contempt of Congress trial, right? You also have people like Judge Nichols, who was appointed by Trump, who oversaw the Bannon trial. We'll talk in a little bit about Judge Amy Berman Jackson, but you start learning about all of these judges and getting a feel for them. And in the DC circuit, to be fair, even though I think a lot of the Trump appointed judges have approached these January 6 cases with a little bit more of a degree of skepticism than the totally pro-democracy judges, I think you've got overall a pretty fair shake in the DC circuit of judges following the law and handling themselves admirably, in stark contrast to what we see with Judge Eileen Cannon in the Southern District of Florida, who's just like totally rogue, which is why we highlight her absurd and just destructive rulings. But this next case, is before Amit Mehta, which tells me the rule of law is going to be followed. He's a no-nonsense judge. He's a deep thinker of a judge. And this is the Oath Keeper seditious conspiracy trial. If you're an oath keeper, it's probably the last courtroom you want to be in, is before Amit Mehta, who's not going to let any of your attempts to politicize the trial or inject things into trials that shouldn't be in there. But jury selection completed last week. When you heard about the jury selection process, though, you really saw the impact that it had on people from the DC area who saw the violence firsthand. So finding a fair and impartial jury pool through the voir dire process, which is the process by which you select jurors in a case. Jurors in federal courts usually receive a questionnaire first to then become pre-qualified. And then once they get past the questionnaire phase, because you may have a panel of a few hundred people, they do the questionnaire, and then lots of people will be disqualified based on their answers in the questionnaire. As Judge Amit Mehta made clear in the jury selection, the fact that you have some relationship to that date is not in and of itself a disqualifying factor if you can make sure that you would follow the law itself and go where the law leads as opposed to where your inherent biases may lead. But the questionnaire process led to about 45 jurors who were pre-qualified. The juror selection was then, that voir dire process was directed at those 45. The panel was finally selected. They'll be sworn in on Monday. But this is a big charge against the Oath Keepers. Their head, Stuart Rhodes, the one who wears the eye patch, and the history of his eye patch was that he wouldn't actually, first he shot himself in the face, is why he got in the situation in the first place. And then his children said he wouldn't ever clean it. So it got infected to the point where he has to wear an eye patch. We actually had him on, his kids on the Tony Michaels show. So we actually got that firsthand insight here. But in any event, the Oath Keeper seditious conspiracy trial, the allegation essentially was that they're trying to overturn our government, that they were engaged in a coup. I mean, we could go through the elements in a little more detail, but that's the essential claim. That trial will start, and it is a big, big deal, an important case for the Department of Justice. There have been prior, I believe, Popak, if I'm not mistaken, some prior plea agreements where people have pled guilty to that charge.
And they're going to testify at this trial.
They're going to testify and be cross-examined. But here, this is really the first seditious conspiracy trial with this Oath Keeper terrorist leadership group. And it's so important because they are connected to that next tier, which are that next layer of people who were close to Trump, which is the next part of the ladder where I believe the DOJ is going. This is to the Jeff Clarks and the John Eastmans and the people like that in Trump's kind of inner circle, potentially the Meadows and people who connected that directly to Trump. So what do you make of jury selection in this trial, Michael?
Yeah, and I'll comment on what you just said about the substance and the importance of it. So To remind everybody that follows and listens to us, this is the trial of half of the Oath Keepers, including Stuart Rhodes, its leader and founder. The other half are going to go several months later, also in Judge Maida's courtroom in District of Columbia. And of all the people arrested, over 800 by the Department of Justice and the FBI, of all the people who have already been convicted, over 260 convictions, there's only this group and another group of Proud Boys who have been charged with seditious conspiracy. A number of them, which is the highest charge out there. If you remember, some judges, including Judge Nichols, questioned whether seditious conspiracy was the proper charge, or interference with or obstructing Congress was a proper charge as well. But be that as it may, there is a series of people, including at least 3 witnesses who are going to testify, because the government has already revealed it, at the Oath Keepers trial, who were Oath Keepers or former Oath Keepers who already pled guilty to seditious conspiracy and are going to testify against Stuart Rhodes and his compatriots there, who are all in charge of things. We cannot overstate the importance of this trial to the Department of Justice. Yes, they are 7 or 8-0 in the trials that they have put on, but this is the one on the seditious conspiracy charge that they have been using as the giant club against all of these people. To lose this would be a tremendous black eye to the Department of Justice. Knowing that, and having seen their trial preparation and their trial presentation in the other trials that they have put on for lesser charges, we know what to expect. It's going to be a lot of video clips of these people, these yahoos, these insurrectionists. It's going to be audio clips from the apps, the walkie-talkie apps that they were using, thinking that they were going to be, scrambled and secret, but that the government was able to obtain in the process and reveal. It's going to be live testimony of witnesses against the defendants who were part of the Oath Keepers conspiracy. It's going to be video from body cams that these people were wearing, from GoPros that these people were wearing, and cell phone video and audio, as I said before, from their conversations, all spliced together in a very coherent timeline for the Department of Justice to educate this jury. I think the Department of Justice is reasonably happy with the jury that's been selected. It's half of it are women, the other half are men. Some of them, as you said, Jan 6 touch them. They know a witness because there's a list of witnesses, for instance, in the questionnaire. Do you know these people? Here's the 30 people who we think could take the stand. Some of them said, I know that guy. I go to church with that person, or school, or this or that. That is not enough to disqualify when you're going through that process. And just to comment on voir dire for a minute, the jury selection process. In state court, where you and I also practice, you get a lot of leeway in doing your jury selection. In federal court, it's really run a lot by the federal judge. There's the questionnaire. The judge will do some other questioning. He'll give it over to the lawyers, but you can't do what you normally do in state court, which is you put on your opening argument in front of the jury and see who bites. I like number 6, number 9, number 12. They seem to like me. It's very hard. You have very limited interaction with the jury pool in the selection process in federal court as compared to state court. And at the end, I think you get the jury. You get the jury that you can select. There's no perfect jury. And so I think on balance, the Department of Justice is probably happy with it. And they got to hope that they can avoid one person getting hung up with Stuart Rhodes' defense, which he's already previewed in filings. Now, Stuart Rhodes, who's, big man on campus, Oath Keeper, I'm going to, support Trump, my president. No one squealed louder than him to try to avoid this trial. He filed motion after motion after motion to delay, to fire his lawyers, to bring in new lawyers, to separate himself from the other Oath Keepers and have his own personal trial. And the judge was, like you said, Judge Maida wasn't having any of this. He's like, no, you're going to be roped together with your co-conspirators in one trial. There's 2 sections of this group that are going to go only because they can't fit all of them in a courtroom. If the potential conspiracy is so large, Ben, they couldn't try all of them together in one courtroom. So they had to separate them. That's the only reason. Otherwise, they'd all be like 20 of them all sitting at some sort of elongated defense table. So he's got to go no matter what he's filed. He's also previewed, well, I want to get your take on this one. He's going to say, the others thought that the president was going to exercise his rights under the Insurrection Act of 1807, which Jefferson signed, which is a one paragraph, like no statute or law that you and I have ever seen, because it's literally 5 lines, and it gives the president tremendous power to put down an insurrection, whatever that is, by use of a militia, which then you have to go search around from 1807 as to what a militia is. And Stuart Rhodes is going to testify that he thinks that he was the militia of Jefferson's dreams, that he was waiting for his president to give the go order, and he was going to put down the insurrection being, this is the upside down world, not the obstruction of the peaceful transfer of power to Joe Biden, but that Joe Biden had stolen the election, and the people in Congress who were doing their job constitutionally to turn over power and count the votes for the Electoral College were the insurrectionists. This is the upside down, fevered, hash pipe dream that these people live in. And so I was just waiting for the 1807 insurrection law to be exercised or triggered or invoked by my president, and I was ready to go. It never came. Okay, well, I never did anything, even though I had weapons and ammunition and munitions that I brought into the Capitol, and I had golf carts ready to storm the Capitol with these munitions. But the go sign never went, and so I'm not a member of a conspiracy. We know that fails under conspiracy analysis, and that fails under the fact that he's not going to be able to get Donald Trump to take the stand. Donald Trump's not taking a stand in his own cases. He's not going to take the stand in Stuart Rhodes' case and say, yeah, I was this close to invoking martial law and the Insurrection Act of 1807. And yeah, these were going to be my guys. This is my militia. Never happening. But the question is, can they get one juror, to believe that somehow that defeats criminal mens rea, criminal mental state? And if it does, this guy could walk. But I'm not sure that happens with a DC jury, but I want to get your view. Do you think they can get one person to buy into this defeated criminal intent, therefore he can't be convicted of a crime?
No, and you're going to have one of the reasons he wanted to sever and have his case tried differently is because the cross-exam that's going to take place of each of these criminal defendants when they take the stand and try to advance that argument that you just made, any trial lawyer that's worth anything to be called a trial lawyer will be able to dismantle and destroy that line of responses very, very, very quickly. And I think that actually testifying to that versus just invoking your fifth and not saying anything and just hoping it goes your way, and that seditious conspiracy is a tough crime to, it's been hard to prove that, and maybe focusing on just the obstruction aspect versus going for, taking the stand on all of it. I just think it would piss jurors off to the extent anybody would be on the fence, and I can't imagine that would be the case. I just think that, it will aggravate and anger jurors to hear that that's actually what the position's going to be.
I agree with you. And he could change his mind, because they're always have high braggadocio before the trial starts. Like, I'm going to take the stand in my own defense. And then the trial comes and goes, and the guy never took the stand. He has said publicly that he's going to take the stand, but that could change minute by minute. As soon as he sees, all's great, but in the fog of war in the courtroom, all your plans that you had in your head, and these are people that we've already seen as sort of addle-brained when it comes to planning. If they think the trial is going to go a certain way, wait till opening statements, wait till all the video and audio gets run, wait till they see the reaction of the jury, a live jury in the box. And in that fog, all of a sudden it's like, you know what, maybe I'll just stand down and not take the stand.
Have you got your Wheels of Justice shirts yet? The long sleeve shirts for this fall and winter. Head to store.midastouch.com and get your Legal AF Wheels of Justice long sleeve t-shirts. That's store.midastouch.com. If you also want to support independent media like this, we're not funded by any outside investors. If you want to help grow this and get access to exclusive benefits, head to Patreon patreon.com/Midas Touch. That's patreon.com/Midas Touch. And today's program is brought to you by Athletic Greens, the health and wellness company that makes comprehensive daily nutrition really, really simple. With so many stressors in life, it's difficult to maintain effective nutritional habits and give our bodies the nutrients it needs to thrive. Busy schedules, poor sleep, exercise, the environment, work stress, or simply not eating enough of the right foods can leave us deficient in key nutritional areas. AG1 by Athletic Greens, the category leading superfood product, brings comprehensive and convenient daily nutrition to everybody. And what I love about Athletic Greens is before it, I would take all of these gummy vitamins and pill vitamins, and it was not doing anything. But then I took Athletic Greens. It was cheaper than my cold brew habit, and this stuff tastes really, really good. It was this one scoop of this green powder that I put in a cup, put water in, shook it up, drank it, and it was great. One tasty scoop of AG1 contains 75 vitamins, minerals, and whole food sourced ingredients, including a multivitamin, multi-mineral, probiotic green superfood blend, and more in one convenient daily serving. It's lifestyle friendly, so whether you eat keto, paleo, vegan, dairy-free, or gluten-free, this is for you. It contains less than 1 gram of sugar, no GMOs, no nasty chemicals, or artificial anything. And as I said, it tastes really, really good. So join the movement of athletes, lifeleets, and legal A efforts and get the nutritional product that you really need in the simplest manner possible. AG1 is essential nutrition. And to make it easy, Athletic Greens is going to give you an immune-supporting free 1-year supply of vitamin D and 5 free travel packs with your first purchase. Just go and visit athleticgreens.com/Legal AF today. Again, simply visit athleticgreens.com/Legal AF and take control of your health and give AG1 a try. And Popak, I want to talk about going and switching gears from the jury selection in the Oath Keeper seditious conspiracy trial to the sentencing of an insurrectionist by the name of Kyle Young, who actually brought his 16-year-old son with him. And this was one of the people who held down DC officer Michael Fanone, passed the taser to the person who attacked Michael Fanone, that you could hear him in videos saying, hold him down and hold him down. Judge Amy Berman Jackson overseeing the sentencing in federal court, the judge hands down the sentencing. She first addressed Kyle Young and said, I want you to know you're not a patriot. You're not a political prisoner. You are a traitor to this country. And what you tried to do and what you attempted to do is to destroy what makes our country truly great, which is the peaceful transition of power. So don't you dare whine that this was about your First Amendment. Don't you dare make these claims that you're some patriot. You are basically scum. You know, I'm paraphrasing slightly, but she said that. And then she said, and I want to speak to all of those people out there, referring to MAGA Republicans, who are inspiring this type of conduct. And she called them out and said, how dare you pledge allegiance to one man who knows that he lost an election and spread the big lie versus affirm your oath under the United States Constitution? And how dare you continue to spark violence and say things like, if this one man referring to Trump is held accountable, people will riot, obviously talking about people like Lindsey Graham. You know, and these statements by Amy Berman Jackson, you know, were strong, but they were apt and they were appropriate. You know, Amy Berman Jackson also oversaw the Roger Stone trial in connection with the Manafort's case as well. So she was the presiding judge over those cases, upheld the law there, She was attacked by them as well. I think they like tweeted out photos of her or posted photos of her with like crosshairs, try to encourage people in their stochastic terrorist way to try to, harm her and potentially kill her, and she just had enough and made it very clear at the sentencing hearing, what the issues were at stake. And she gave a call to the judiciary too. And it is the judiciary's obligation to stand up and uphold the Constitution where a political party is clearly failing, with referencing obviously what MAGA Republicans are doing. What do you think about the sentencing and her words more broadly?
It's the reason why it's called the wheels of justice. It's not the wheels of the executive branch. It's not the wheels of legislation. It's the wheels of justice. And she talks about the importance of a strong judiciary as the last firewall for democracy to make sure, as Jamie Raskin once aptly commented, there's not an accidental toppling of our democracy, which could have well happened on Jan 6th had it just gone a hair further to the right. So I like Amy Berman Jackson a lot. You and I do. Pardon me. We've commented on her in prior podcasts. And she did not have to, in sentencing, address him or the other multiple audiences that you talked about in one of your trending takes that she was talking to. Kyle Young and his family didn't even have to be in the courtroom for most of what she was talking about in the sentencing, because she was talking to a different audience. She was talking to the American people. She was talking to, as you said, fellow jurists, regardless of their political persuasion. She was talking to the Republicans and the MAGA right-wing Republicans who've bent the knee to Donald Trump and have, as a result, abdicated their responsibilities under the U.S. Constitution. She's talking to them as well. Let's not forget Michael Fanone for a moment. And I don't think we can talk about him enough. Police officer Michael Fanone, a 20-year veteran, not only was brutally, horribly beaten with his own equipment by the crowd, including leaders of the crowd, like Kyle Young, who pinned his arms against his side so that he couldn't call for help, and he couldn't use his sidearm, who put him in a position to be bear sprayed and tasered. And Michael Fanone, who was a well-built man, middle-aged man, police officer, had a heart attack during that attack. That's how brutal and devastating that was to his entire system. But not just a brutal attack on his body leading to a heart attack. He left the force and testified, which he's purposely permitted to do, and it's appropriate as a victim. Before the sentencing, he testified, and he looked Young in the eye and said, "I hope you suffer in prison the way that I have suffered, because I've not only lost my career because of you, because I had psychologically had to leave the force." He says, "I've lost my faith in law enforcement, in the institutions of this government that I gave my life to and my career to. You've taken that away from me as well." Another set of powerful words in that courtroom were by Michael Fanone in addressing the judge in sentencing. And of course, there had to be an a-hole in the audience when Michael Fanone said to Young, "I hope you suffer in prison because I've suffered." Somebody yelled out, "Oh, you're an a-hole." I mean, literally, even today, there is a group of people, and we can't do a census of them and figure out what percentage of it is in the electorate. But even the day that Fanone's, what happened to him is described in a courtroom, and what Young did to contribute in a criminal way to his beating, senseless and maiming of another human being, somebody else thought it was appropriate to yell out in the courtroom and attack Michael Fanone. Totally inappropriate. So she sentenced him. Amy Berman Jackson sentenced Kyle Young to over 7 years, 86 months. He has already served 18 months. These Jan 6 people, rightly so, have been in detention, pretrial detention, for all this time. So he's been in for 18 months. I'm pretty sure he gets a credit for the 18 months.
This is one of the people, though, Popak, who Trump is calling a political prisoner when he says that.
They all call him that. Yeah, and that's why I loved Amy Berman Jackson. I love her for many reasons, but for her to come out and say, you have not been prosecuted and convicted because you exercised your First Amendment right. You have not been prosecuted and convicted because you were peacefully protesting something that you believed in under our Constitution. You were, and as you said, you are not a political prisoner. You are not a patriot. You are none of those things. You have been convicted and prosecuted and convicted because you committed crimes against this country for which there is no excuse, and you're going to jail for a long, long time as a result. And the fact that he brought the 16-year-old with him is just mind-boggling. Now, Kyle Young, at least in terms of his own defense, he has said that he's a changed man, that he realized it at the end that it had gone too far. And she said to him, you want me to believe, Mr. Young, that this was a momentary lapse of judgment and a little bit of a contact that you had with Officer Fanone. That's a lie. That's a lie. We have the video of what you did and the audio of what you did. You were a leader in the brutal attack, the first line of defense at the Capitol steps of Officer Fanone, who got swarmed and rushed by the crowd that you led, and we have the result as well. So I loved it for many, many reasons. More judges in doing their sentencing should actually, for history's sake, speak to these multiple audiences as eloquently as Amy Berman Jackson did. But first of many, we're not done. We're up to 260 convictions and sentencing. And that's not the last Kyle Young that you and I, unfortunately, are going to have to talk about. It is the fourth highest sentence on the, if you look at the Department of Justice database, that any of the insurrectionists has gotten. So it's up there. People that in the beginning were wondering, why are these people getting off with misdemeanors? They're not. You start at the bottom, you end at the top as we move to hopefully that next level of prosecutions of the people that were in the White House and the Trump campaign assisting the president.
I put Kyle Young in tier 2 in the hierarchy I have. So that kind of tier 1, I have people like the shaman and a lot of like the real kind of cultists and people who maybe didn't do violent things, but nonetheless desecrated, stormed into the building and trespass. Tier 1. Tier 2, the more violent people, people like Kyle Young who assaulted, who were more instrumental in engaging in the violent conduct. Tier 3, I have the terrorist organizations like the Oath Keepers, like the 3%ers, like the Proud Boys. Tier 4, I then have the people who have not yet really been indicted. I put these people like the John Eastmans, the Jeff Clarks, the Pillow Guy, who went in, and the Cash Patels, even the Mark Meadows, that next tier right above the 5th tier, which I have as Trump. And they've really yet to go to that 4th tier yet, although a lot of those subpoenas that we've been hearing about that have gone to people like Stephen Miller, that have been sent out. I think there's about 40 other subpoenas that have gone out, and we've heard about all of the grand jury testimony that's been taking place. That's aimed at that 4th tier, search warrants being executed on phones. And I think we'll start seeing indictments there as well soon.
It's the ultimate multi-level marketing pyramid scheme against America. All those tiers you just did, those are just steps up the pyramid until you get to the very top, which is, as you said,
it's a little bit of a layup there. You gave me a little bit of a layup there too. and this wasn't on necessarily what we're going to speak about, but it is related to kind of Trump's deposition. So he's being sued civilly in one of the number of class actions he's being sued with for engaging in one of those pyramid schemes relating to the Celebrity Apprentice and, fraudulently telling people about get rich quick schemes. And a class action was filed against him and the organization that was selling these BS classes and products. So the deposition was scheduled to take place at Mar-a-Lago originally this past week. But when the hurricane was set to hit, the lawyers, for the plaintiffs' lawyers representing the class, said to Trump basically, hey, the hurricane's hitting in Florida. We're not going to fly down there to Florida to take your deposition. Why don't we take your deposition in Bedminster? Well, let's come up with a new location so we're all safe. Donald Trump got on a plane, flew into the hurricane so that he could avoid the deposition. And then he tried to file a motion with the judge in that case because he tried to delay his deposition. So the final deadline of when his deposition could be taken was last Friday. So then the class action lawyer sent a letter to the judge and said, look, the hurricane's going to hit. We're not going to fly down and potentially put all of our, the court reporter, the lawyers, the staff in peril of potentially getting killed. And then Trump's lawyers wrote a letter saying, too bad, so sad. You blew your deadline to depose Donald Trump. The court stepped in and said, that's absurd. I'm going to continue the deadline until October 31st. But you said the pyramid scheme. And so Trump was supposed to be deposed on Friday. And he literally went to the hurricane
to avoid
his deposition.
So you and I are always good at weaving things together. We're going to talk about E. Jean Carroll next. In the same week that he tried to avoid the deposition by flying into the eye of a hurricane to get away from it, he also has filed papers in the case against E. Jean Carroll. Now that the Second Circuit that you and I are going to talk about has ruled partially in his favor on one aspect of what he's trying to accomplish there, which is to get out of her defamation case. And he said, well, I don't want to give my deposition. I was going to give my deposition, but I don't want to give my deposition now to the lawyer, Robbie Kaplan, who's representing E. Jean Carroll, because I may win this appeal and I don't want to do that. And of course, Robbie Kaplan came back with, here's another example of him trying to avoid his deposition. Although she wrote one thing that, I don't know if you caught it, Ben, which I did not like and I don't think is true. She said he's trying to play out the clock until he is elected president again in 2024. I think she should have said potentially elected president. I don't really think that's going to happen. But her point was he's just playing delay. He should sit for his deposition now in E. Jean Carroll while we go through the appellate process and not the other way around. So two depositions he tried to avoid, consistent with his obstructionist conduct to delay until something, as you've said, the law of holes, as I've said, when things go badly, make them go badly slower because time is on your side at that point. He's trying to do that aspect of that principle.
E. Jean Carroll's lawyer, I mean, she's first rate. I mean, she's top of
Yeah.
I'm with you. I didn't love the letter too. The letter also started talking about the search warrant that was executed at Mar-a-Lago and Trump's positions there. I think there was so much in it. She could have just said, look, his deposition scheduled for October 19th. Yeah. He's going to, and she said this, but all that other stuff was in there. He's going to be deposed in this case or the other case because she had previously filed the motion letting the court know, or a letter brief, because in New York you just file letters with the judges, which is also something that's such a wild
Dear
concept.
Judge.
Yeah.
Dear
you
Judge.
file all these letter briefs, but letting the judge know that there would be a claim that was filed under the Adult Survivors Act, which revives the statute of limitations for adults who were victims of sexual assault and extends the time frame for which they have a new window. So I believe New York's new statute of limitation for sexual assault is 20 years, but that's prospective and is not retroactive. So what this Adult Survivors Act said is that for people who were sexually assaulted in the past, we'll give you a window. Was it a 1-year window, Pope?
Yeah, it's a 1-year window starting 30 days after Governor Hochul signed the new statute. It's that recent. And the 30 days is, I think, the 23rd of November, which is the first day that anyone, including Robbie Kaplan for her client, E. Jean Carroll, can file. So 1 year from November, I think 23rd, anyone who is an adult now who says that, who was an adult when they had an alleged sexual assault or abuse happen to them, because there was a separate child survivor statute that the then Governor Cuomo signed that gave a similar 1-year open window, last chance to file, that already expired. This is now for adults because, of course, E. Jean Carroll was an adult when she says she was raped in the dressing room of a high-end department store in Manhattan in 1995 or 1996.
And so the case that was currently pending before federal court was actually not a case involving the actual sexual assault and the rape itself. It was a defamation case because Donald Trump gave a press conference where he said a number of derogatory things about her appearance and her looks, and then denied that it ever happened. And then E. Jean Carroll sued for defamation. She sued in the New York State court system. As discovery was about to take place there, the Department of Justice swooped in and under Bill Barr asserted that Donald Trump was not the proper party to be sued because he engaged in whatever the alleged conduct, the spoken purported defamation is what Bill Barr would say happened during a press conference in connection with his role as the president, and therefore the proper party is the United States government. So the case should be framed E.G. Carroll versus the United States government. And because the United States has not waived sovereign immunity as it relates to defamation cases, by substituting in the United States, it would act to dismiss the overall case. But the federal judge in the United States District Court there specifically made the finding that the United States was not the proper defendant, found that Trump was not acting even as an employee of the United States government when he made those comments, that the unitary executive is outside of what the definition is and of a government employee. And in any event, his conduct was not in the course and scope of his employment. So the bizarre thing here is that after the district court judge made that ruling, Merrick Garland and the Department of Justice, because by the time this happened, Biden was the president, but the Department of Justice, and many people thought was the Department of Justice going to change the position from what Bill Barr had said. And I think it's something which upset a lot of people about Merrick Garland. And I think Merrick Garland has reignited a lot of confidence in his overall approach to justice as the wheels of justice have turned and as he's handled all these other investigations and prosecutions. But this was one that was a bit of a head scratcher, that the Department of Justice continued to pursue Bill Barr's policy and appeal, and saying that the conduct, because it occurred during a press conference itself of the president speaking, should have been viewed as a government action in the course and scope, and the United States government was the proper party, even if we don't like what the outcome would be, in order to preserve and protect the fact that most presidents are not, pretty much all of them, are not demented lunatics like Donald Trump. And what Merrick Garland was trying to preserve and protect is not the case, where this is an extreme example where a president goes and demeans and does all and lies about a sexual assault, but where someone like Biden is giving a press conference, he's asked a question and says something about someone, and then everybody starts suing the president.
Well, do it this way historically. Bill Clinton, who's on our side of the aisle, gave a press conference in which he denied accusations by Monica Lewinsky that they had an affair. And everybody remembers that crooked finger where he pointed it and said, "I did not have sexual relations with that woman." We know now that wasn't true. But Monica Lewinsky could not sue Bill Clinton and did not successfully sue Bill Clinton because this is the Department of Justice's position under Merrick Garland and under Barr. A president is allowed to deny allegations against him, whether sexual in nature or other things in nature. I did not breach that contract. I did not have sexual affair. I did not, run over my neighbor's cat, whatever the allegation is, without being subjected, without losing the immunity that comes under the Westfall Act that Congress has provided to a government employee, in this case, the president. And so we didn't like it when Clinton did it. And certainly it's a whole different, it's like comparing apples and bowling balls as to what Trump has done versus what Clinton did for his impeachment. But the principles are the same. And so the Department of Justice under Garland held its nose, put its fingers on its nose and said, we don't like what he said. And he's a little too far when he said, she's not my type, so that couldn't have possibly have happened. But a president in office is allowed to deny allegations against him. And we're going to stand by that principle, whether we like it or not. And that's why they continue to pursue that policy. You want to talk about what the Second Circuit did?
Yeah, let's talk about what the Second Circuit did. So the Second Circuit, you're not going to catch me looking at my cell phone text messages twice, Michael Popak. So the
Salty, I want a split screen side by side. Don't cut away from me. I want a split screen of Ben doing whatever he was doing at the moment I asked that question.
So the Second Circuit ultimately made a very discreet ruling and then kind of punted the rest of it to the DC Circuit. And they said that under the provision of what constitutes an employee of the government, to then analyze whether the employee, step 2, acted in the course and scope under what's called the Westfall Act, that Donald Trump would have been appropriately characterized as an employee. But whether he acted within the course and scope of his employment such that the United States government should be substituted as a defendant, that second step analysis, the Second Circuit just said, you know what, let's go and ask the DC Circuit what they feel about the issue. So they did something that's rare, but on these, I guess, tough, broader constitutional questions, you see it from time to time, which is to certify the question and issue to a court that is more of the appropriate authority in the area. So they certified was it within the course and scope question, and now that process will be briefed and heard before the DC Circuit. Meanwhile, the deposition of Donald Trump is still set for October 19th by E. Jean Carroll's lawyers. And so the question is will that take place? But what do you think about the DC Circuit being involved in this now?
Yeah, it's actually the DC Court of Appeals. We talked about it on Wednesday because it was something we had to unpack. I don't know if you remember, this is like Stump Ben Day. Ben, do you remember we talked about the DC Attorney General investigating the inauguration fraud, literally the Trump fraud number 1, day 1 from his inauguration? And
and they had that lame settlement. It was like $500,000 or something.
But we got to discover that there was a DC Attorney General who sits in the municipality of the District of Columbia and wears the hat of being an attorney general, which would be the equivalent of a state attorney general like Letitia James. Along with that, there is a court system in District of Columbia that is independent from the federal system. Even though it's a federal territory, it has to have its own court system because, people live and work in District of Columbia. They don't all work in the Capitol. They work in a coffee shop. They teach. They do what, they're firemen, and, they live a life inside the District of Columbia. That's where they live. And so there has to be a court system for them. And the highest court for that court system, I'll call it a municipal court system because they're not a state, a territorial court system, is the District of Columbia Court of Appeals. It's their state Supreme Court, their version of it. And this issue, this very esoteric issue that the Second Circuit kind of wrapped themselves around their axle about was, all right, we're going to find he was an employee. I mean, look, he got elected to a job. He gets paid to do a job. His job is being the president. He's an employee under the Westfall Act. But the second question is, as the employee, was he within the course and scope of his duties? Let me give an example of what that means. You've got a FedEx driver, an Amazon driver. The course and scope of his duties are to go from house to house and business to business delivering packages. If while doing that, he steps out of his truck, has an argument with the homeowner and punches the homeowner in the face, is that within the course and scope of his duties? Or did the course and scope of his duties stop at the moment he opened his door, stepped out, and drew up his fist? And so if he's outside the course and scope of his duties, then in this scenario, Amazon and FedEx are responsible for or liable for that driver's bad acts. If he's within the course and scope of his duties, they are. And that's a concept that you and I call in the business respondeat superior, meaning vicarious liability, holding somebody else liable, in this case, the employer, for the acts of the employee. Same analysis here for the president. Are we going to hold of the federal government responsible? Therefore, the U.S. can intervene in the case, taking Trump out and enjoy sovereign immunity to avoid the defamation case? Or is he outside the course and scope of his duties as president when he went, and said all those statements denouncing E. Jean Carroll, not just saying it's a lie that it happened. That's one thing, but saying including all those other things. Denny Chin, appointed by Obama as on the Second Circuit, wrote in dissent, because it was a 2-1 decision, that there's no way that a president basically stepping out to call out an accuser and claim that the thing didn't happen and that there's no way I would have ever sexually assaulted this woman, look at her, is within the course and scope of being the president of the United States. And therefore, that I think is going to be the roadmap. But how the other two, this was a 3-male panel, the other 2 men, and this was like, one Clinton, one Obama, one Trump. So we had the full, cherry of, the process here. They said he's an employee, but we're not sure about course and scope because the law of the District of Columbia, not the federal law, the local law of District of Columbia on this issue, which the parties agree applies choice of law, is unclear and unsettled in the area of respondeat superior. So we need to get guidance with a certified question, as you said, Ben, to the highest court of that territory, the Court of Appeals of District of Columbia. Come back and tell us the result. Do you think that he's within the course and scope? Give us more guidance. Brief it. Come back to the Second Circuit, depending upon the ruling, and we will then make the ultimate ruling on this case. That will delay this defamation case for a long time. This is not an expedited appeal. This could be a year or more wending its way through all of these processes that we've just outlined. But for those that think he'll never come to justice against E. Jean Carroll, E. Jean Carroll's got the civil rape claim that she's going to file on November 23rd. That's going to be completely in her favor. And that, just to anticipate a question, is likely not going to be covered because that rape alleged happened before he was president. And therefore, I don't see Merrick Garland intervening and saying that there's some sort of doctrine that has the U.S. substitute for a citizen Trump sexual crime in 1995. And even if he did, it would be outside the course and scope because it's an intentional crime or tort is always outside the scope of employment. It's never within respondeat superior. So there's under no scenario is the U.S. going to substitute in the civil rape case and take Trump out of that. He's going to have to sit and be a defendant in that case against E. Jean Carroll.
Yeah, and there he wasn't the president at the time, too. He wasn't during a press conference. Exactly.
Right.
And, ultimately that's where I think Merrick Garland, who thinks deep about these issues, wanted to protect and preserve, not the Bill Clinton example you gave, Popak, although that's on the fringe. I think Merrick Garland wanted to focus on, look, there's a lot of things that presidents can say when they're giving press conferences, not like a Clinton, not like a Trump, but just say things. And if they can be sued for saying whatever they're saying as the president, there's going to be potentially a lot of lawsuits. Some may be meritorious. A lot will probably be frivolous, if he just mentions and brings up that. But regardless, this should be an area where we're not waiving our sovereign immunity, and all of those cases should be dismissed. So he was trying to protect and preserve an institution that Donald Trump, unfortunately, comes in as the bull in the china shop and tries to destroy the institution. And so that conflicting aspect makes Merrick Garland's appeal feel callous, when in actuality, the deeper, broader plan is the underlying conduct at issue that E. Jean Carroll is alleging, the rape, there is a day and a place in court and justice for that conduct. And did Merrick Garland know that New York was going to absolutely pass the law when he did this? I don't think he definitely knew, but there were certainly signs, and I'm sure he's aware of it because, unlike his predecessors, he reads and studies legislation and the national trends. I think he knew that was going on anyway, and that type of law was working its way through legislatures, and that E. Jean Carroll would eventually have her day in court. And so he was willing to bite the bullet to protect an institution and look bad temporarily, but ultimately let the wheels of justice take its course.
Yeah, and we've talked on this podcast really early on about another principled position that Merrick Garland's Department of Justice took, which we didn't like viscerally, but it was the right decision to make in terms of, as you said, the long view, which is when Trump had the park cleared of all the protesters, right, on the way into church. And same thing, Merrick Garland stepped forward. I just called him Justice. He should be Justice Garland. Merrick Garland stepped forward and took the position, not for today, but for the future, that it would be a terrible precedent for future presidents, not named Donald Trump, to be subjected to liability for doing something kind of akin to that, or for doing, if he had a natural fear for his safety and security and not being able to do those things in the park. We don't always agree with the decisions, but as you said at the top of the show, we know what we get with Merrick Garland is a reactivation of a principled, measured, sober, rational approach to justice. This is the reason you have to vote for Joe Biden. This is the reason why you get adults in office like this, because the policies that are enacted, you may not agree with them. I was thinking of something when you were talking about the peaceful transfer of power. I was thinking about me, and I was thinking about every 4 years, I would dutifully, since I was a child, I would dutifully watch an inauguration, regardless of who won the presidency, because I wanted to see the peaceful transfer of power, even if two people in their campaigns were at each other's throats, in the campaigning. At the end, to see, these two people sitting next to each other, congratulating each other, and so the history of America progresses and continues. I wanted to see that, and I loved seeing that because it gave me tremendous confidence in the stability of this country until Donald Trump. And
I don't know if you saw the interview that Hillary Clinton recently gave, where she said that too. And she said, look, when I lost the election, I was there in my capacity as a former first lady. And I sat there because I believe in the peaceful transition of power.
Right.
And as I was at that speech, I genuinely wanted Trump to go out there and unite the country. Despite all of the, issues that existed and everything. And I was hopeful. And then he gives that speech. And all I could think about with American carnage. And she's like, that was really horrifying. And she goes, then George W. Bush whispers in my ear, that's some real weird shit right there.
It's a crazy shit, right?
That's some crazy shit right there, and she was like, yeah. And then from that day on,
yeah.
That's why you got to believe these MAGA Republicans when they say things like we should abolish the VA, or we want to seriously consider taking away Social Security and Medicare.
How about holding a constitutional convention? How scary is that? They want to call a constitutional convention that we haven't had since 17 whatever to amend the Constitution.
Yeah, and it's very, very, very dangerous stuff. But the wheels of justice turn still in the right direction. And this is why Popak and myself and the Midas Touch Network, why we've jumped in to this arena, and why our independent media is doing what I don't really think there's much media doing, which is calling out traitors as traitors, exposing and calling out MAGA for what they are and the threat that they pose, and not both sidesing the issues and talking about the real ramifications that are at play. That's why I love doing this each weekend with you, Michael Popak. That's why I love that this is not just a network, right? It is a movement. And for everybody who listens and watches this, watching it is not a passive process in the Legal AF and Midas Touch community. Watching this is just one of the steps of the movement, where then everybody goes out into their communities and registers voters and spreads the truth and talks to people about these issues. Our message is a coaching strategy, if you will, to the audience. But then the audience, we rely on you to go out there in your communities and to spread the truth and to call out the lies and to not let, and Popak, you mentioned this earlier, I'm not sure the percentage of these MAGA people out there and what they are, but they certainly represent a small portion, but a loud and vocal portion of people out there. And we've heard that term before, the silent majority, which was used inappropriately in the 90s by the precursor to the current MAGA Republicans. But truthfully, the silent majority of people that exist in this country want to just go about their lives with normalcy. They want to have hobbies. They want to speak with friends. They want to go into grocery stores and not have their food spit on by conspiracy theorists. We want to take pandemics seriously and not lock up scientists. We want peaceful transitions of power. We don't want insurrectionists. We don't want QAnon, weird, dangerous cult behavior out there. We want to give people their freedoms. We want to give women their freedom to choose and to make decisions over their bodily autonomy. We don't want governors like Greg Abbott and DeSantis kidnapping people and taking them abroad and having PR stunts. We just want stability over the MAGA dangerous stupidity. And it's really, really, really up to all of us to spread these messages of truth. If you want to support independent media like the one you're just watching right now, again, head to patreon.com/Midas Touch. That's patreon.com/Midas Touch. Join one of the membership tiers there too. Check out store.MidasTouch.com. That's store.MidasTouch.com and get your Wheels of Justice t-shirts. We also have our Rovember, Row Your Vote and Convict and Convict 45. But definitely, if you're a legal AFer and you don't yet have your Wheels of Justice long sleeve shirt, make sure you get that as we're headed into the fall and winter. And then finally, for all of those watching this on YouTube, here is how you can help us out as well. Go and subscribe wherever you get podcasts by audio to Legal AF, and then play it a little bit, because that helps our numbers on the algorithm with the podcast charts. So make sure you do that there. If you're not subscribed to the YouTube channel, hit the subscribe feature right now. We're, I think, at 615,000 subs already. We were just recently at 500,000 subs. This is the fastest growing independent media channel in the world. Just, you know that by following it, that's the case. But make sure you subscribe and get others to subscribe. And if you're watching this, or rather if you're listening to this on audio and you want to check it out and watch it on YouTube, subscribe to the Midas Touch YouTube channel as well. But for now, it's Ben Meiselas with Michael Popak discussing the most consequential legal news of our time, with a special shout out to the Midas Mighty.